Which no-fault category of divorce to choose from? First thing, talk to your spouse and get his take on ending this marriage. If he or she also thinks that the marriage has fallen apart, then it may make things easier. If you both can agree on how you want to divide your assets, you can file for uncontested divorce. Your lawyer can help you put together the separation agreement and financial statements. If your spouse doesn't think that the marriage has to end, or he doesn't agree to the terms of division of assets and custody, then you'll need to file a contested divorce. Joint petition, also known as uncontested divorce. In this, the court will not accept any paperwork until it's completed and signed from both parties. So if your spouse is hesitant to sign documentation, then although the paperwork is all prepared, it will not move forward as both parties must sign several documents, one of which is a separation agreement, which outlines the terms of agreement, financial statement disclosing all the incomes and assets, liabilities of each of you, an affidavit admitting marriage is over, and some other pleadings are required. Most people who are reluctant to acknowledge the divorce will not engage in signing these documents, as they may not believe that the other person is serious and sort of sit on the documentation, or again use it as an opportunity to try to repair their behavior. A contested divorce, on the other hand, is contested only because on day one there is not a full and complete agreement. It doesn't mean that it cannot be converted to an uncontested when there is a complete agreement by the parties. So a contested case can be converted into uncontested, however, it cannot go the other way around. Now, how do you proceed with a no-fault divorce and also save money while doing it? The court expects that a case that is going to a trial would take from start to finish somewhere around 1 to 2 years. This again depends on how much intervention is required in the case. The first time the court has the ability to enter a divorce over someone's objection is at the time of a pre-trial. A pre-trial is only scheduled by the court after there is a service of the complaint for divorce by a constable or sheriff. The pre-trial conference cannot be scheduled for a date prior to 6 months from the date of the complaint, and that may change depending on which state you live in, so you may want to check that. If your spouse is reluctant to acknowledge that the marriage is over, he or she would be more willing to consider an uncontested divorce only after seeing that there is a pending court matter. In these cases, I would suggest that a contested complaint be filed. Then prior to a service by a constable, the lawyer will prepare your financial statement, separation agreement, and other related documents and send it to your spouse along with a regular copy, asking them to participate prior to needing to be served by the constable. Then you give your spouse some time. That's your decision how much you want. Then if he doesn't engage with you, then you serve the complaint, so that way you're not losing time if the court has to grant divorce over his objection. Then after the service returns to the court, you could anticipate a pre-trial date. Depending on his action or inaction after service will determine what overall costs are likely to litigate the divorce. Divorce attorneys usually charge upward of $300 per hour or more. Remember, it's always better to file a contested divorce than applying for uncontested divorce. This is because once a spouse sees things in action and when he gets served by a police constable, they may change their mind in getting an agreement and file for uncontested divorce. The spouse will also need to hire an attorney if they want to pursue a contested divorce, so this may also make them rethink if they want to spend that kind of money for the attorney. Divorce isn't cheap if there are disagreements, so the focus should always be to come to an agreement. The agreement can be reached with ease or with some difficulties, and your due diligence and analysis will greatly help in getting an agreement and will likely reduce some lawyer fees since you'll be doing some of the work. I would take a case of when you and your spouse are almost at the same professional level and earn around the same income. If your spouse is not agreeing on financial asset distribution, then you need to do some work to show what you deserve. The first step will be to get your spouse's financial statement. Your lawyer can help you get it from him or her. The next thing I would suggest you do is list all your assets, including house, cars, your savings, 401k, stocks, etc. List all your liabilities, any house mortgage, car loan, then calculate the remaining equity. You may need to get your house appraised to get the current value, and both you and your spouse total equity will need to be calculated here. Now, if you had assets, any savings before marriage, you can exclude those as premarital savings. Those are usually excluded from having an equal distribution post-marriage. Now, whatever is remaining, divide the number by 2 and then compare it to whoever has the higher equity. That's the share you need to give to your spouse or take from him or her. When you have this number, you have a solid base to argue against. Most divorces prolong because of not getting their numbers right. If you don't do this due diligence, the defendant or your spouse may give an arbitrary number and demand you to give more assets to get a divorce. Because in this case, if you initiated the divorce, he thinks that you want to get a divorce sooner, and he may make some random demands from you to give him or her more money. Don't fall for this. Do your homework so you can get exact numbers and come to agreement sooner. Remember that the defendant may also not want to prolong the case because it's costing him more money to pay his or her lawyer too. So if you propose an offer for an agreement backed by your calculations, they may reach an agreement sooner. Don't think that you need to agree to all his or her demands since you want the divorce. You should get the divorce and also get the financial assets that you deserve. And that's what I wanted to explain in this video. I hope you found this useful and it'll help you make the right decision and take proactive actions. Thank you.